Okay, everyone, welcome to our presentation on surveillance. Everything you ever wanted to know but were afraid to ask. We apologize for the delay. We are having connectivity issues which affected the presentation, but we have sorted it out and we are going to be moving forward. My name is Kathleen O'Hara. I'm a partner here at Strigberger Brown Armstrong. My practice focuses primarily on claims involving misrepresentation and fraud. And I'll turn it over to my partner.
Hi, everyone. I'm Sonia Reed. I am an associate at Strigberger Brown Armstrong in the Toronto office. And being a junior, I'm sort of a generalist, but I do a lot of accident benefits, bodily injury, and fraud work. And surveillance is super relevant in all of those contexts, which is why we decided that we should talk about it today. So without further ado, I'll just give you a brief overview of our presentation. We're going to first talk about the law for investigators and insurers around surveillance, the consequences of obtaining your surveillance illegally or improperly, how you go about getting your surveillance into evidence, both at courts and at the LAT, and then finally some best practices for obtaining your surveillance and getting it into evidence. So the law governing surveillance is really all over the place. There's a constellation of different provisions in different federal and provincial statutes. There's also the common law. So the most important pieces of legislation to know about are PIPEDA, which is the Federal Personal Information Protection and Electronic Documents Act, the Provincial Private Security and Investigative Services Act, which also sets out the code of conduct for investigators, certain provisions in the criminal code, the Provincial Trespass to Property Act, and then the common law tort of intrusion upon seclusion that was set out in a case called Jones and Seagay. And just briefly want to mention that even though it's important to know about that tort, we don't know of any cases where investigators or insurers have actually been found liable of committing intrusion upon seclusion. It's very difficult to establish. It requires a very, very invasive intrusion into someone's very private affairs. For example, something to do with their health records or their sexual orientation, and it has to be conduct that would be considered highly offensive. So again, we've never seen anyone found liable of that for conducting surveillance in the context of an insurance claim. Surveillance in the insurance context is usually protected one of two ways. In the litigation context, parties to a lawsuit are considered to have given their implied consent to having their personal information collected. This is obviously not without limits, however, and the Federal Privacy Commissioner commented on this in this 2005 decision, just saying that you cannot collect unlimited or uncontrolled information. You can only collect personal information to the extent it is relevant to the merits of the case and the conduct of the defense. Outside of litigation, the protection of surveillance is often going to be protected by Section 7(1)(b) of PIPEDA. So that, that's in the Personal Information Protection Act. 7(1)(b) authorizes the collection of personal information without consent or knowledge of the subject, but only where having or seeking their consent would compromise the availability of the information, and where the collection is reasonable for purposes related to investigating a breach of an agreement or a contravention of the laws of Canada or a province. Contravention of a law has been interpreted very broadly. So this is broad enough to encompass insurance claims. The Privacy Commissioner set out 4 criteria that information collection without consent has to meet to be protected by 7(1)(b) in this 2007 decision. So the collection of personal information must only be for purposes a reasonable person would consider appropriate. There must be substantial evidence to support the suspicion that a law is being broken. The organization must have already tried less invasive means, and the collection must be limited to the purposes The OPC has not considered, or the Privacy Commissioner has not considered what substantial evidence actually means in an insurance context. Most of the complaints with published decisions are in the employment context. It has said in those employment decisions that substantial evidence has to be, at the very least, something more than anecdote, has to be more than rumors, and it has to be more than just an observed change in an individual's behavior. In terms of limiting the collection to the purposes of investigation, the Privacy Commissioner also looked at this in the 2005 decision I mentioned a moment ago. This was a bodily injury claim. The Privacy Commissioner did find that the insurer's surveillance was protected by the implied consent rule, but it did not find that the collection was limited to the purpose. So the collection was done over 3 weeks. It observed the plaintiff doing several activities at several locations, and the the investigator's purpose, or the insurer's purpose, was just stated as verification of the plaintiff's identity and location. So they gave a very narrow purpose for pretty broad collection. I think that probably the insurer could have just stated their purpose a lot more broadly, and likely they wouldn't have had a problem. But you need to pay attention to the relationship between how you're going about getting your surveillance and what the purpose of your investigation is. So what happens if you obtain your surveillance in an illegal or an improper manner? There has been a lot of discussion around whether this can result in your surveillance evidence being excluded at court. The Ontario court has never excluded surveillance on this basis, though it has been asked to on a few occasions by plaintiffs. The first big case on this was Frenzy and MCI Medical Clinics. The plaintiff asked the court to exclude the surveillance because she said it had been collected in violation of PIPEDA. The court found that it did not violate PIPEDA. It was actually protected by 7(1)(b). But the big takeaway in the court's holding was that the methods by which the surveillance was collected were not relevant to admissibility. They had no bearing on it. The only factors governing admissibility were the relevance of the evidence, and that its probative value outweighed any prejudice it might cause. A couple of years later, in Cowles and Ballack, a plaintiff asked for surveillance to be excluded, this time because she said it was collected in violation of the rules of professional conduct. So that's the lawyer's rules of professional conduct. In this case, the investigator had actually approached and spoken to the plaintiff because the investigator was an agent for defense counsel. This was considered to be a breach of the rules of professional conduct. But again, the court said the rules of professional conduct has a mechanism, just like PIPEDA does, to deal with this kind of violation. And that is the appropriate avenue of recourse for this type of complaint. It has no bearing on admissibility into court. Then just last year, there was another Superior Court case, Romney and Nelson. This time, the plaintiff asked for the surveillance to be excluded because she said that the investigator had collected it in violation of the Trespass Act. So she was filmed on her wedding day, which took place on a golf course. And she said that the investigator had trespassed on the golf course and at a parking lot across the street of a school. The court found that there was no violation of the Trespass Act. Even if there had been, again, this was not the type of illegal conduct that would warrant exclusion from evidence. It reaffirmed that the only factors governing admissibility are, again, relevance, probative value, and prejudice. But there were some interesting comments made by the court here. Like I already said, they said this was not the type of illegal conduct that would bring the administration of justice into disrepute. So some people have taken that to mean that they were leaving the door open for, some kind of conduct that would be serious enough to warrant exclusion from evidence. They didn't say what that would be, but people suspect that it would probably have to be criminal in nature to be excluded. Go to our next slide. Another potential consequence is a finding of bad faith or some other nasty finding like abuse of process or conspiracy. But again, we've never actually seen these kinds of awards made. Plaintiffs have asked for these kinds of awards and courts have declined to grant them. So the most notable case in Ontario, at least, with Pontillo and Zinger, the plaintiff sued the insurer, the investigator, a couple adjusters personally, amongst other people, alleging abuse of process and conspiracy on the basis of what she called an unlawful investigation scheme. The insurer successfully moved to have the claim struck. The court didn't do a detailed analysis of the abuse of process portion because it was basically just not applicable at all in the circumstances. But as to the conspiracy claim, it explained that to establish a conspiracy, the plaintiff would have to show that she suffered actual damage and also that there had been an unlawful act. There was nothing in the pleadings from which the court could infer that anything unlawful had happened. The only facts that were pled in any specificity were that the insurer hired an investigator, the investigator approached a neighbor and made himself known to the neighbor, and that the neighbor immediately told the plaintiff she was being investigated. So the mere fact that she was being investigated was obviously not unlawful conduct. The court said this could not sustain a claim of wrongdoing or improper motivation, and it actually endorse the routine use of surveillance by insurance companies, even going so far as to say that they're at a disadvantage compared to the plaintiff, just in terms of the amount of evidence or information that they have to contest the plaintiff's claim, and that they're absolutely entitled to conduct surveillance as long as they do so within the confines of the law. Going to go over a couple BC cases now, just because, well, they're relevant because they're also allegations of not bad faith, but of wrongdoing by investigators hired by insurers. In both cases, the plaintiffs asked for a special cost award based on the investigator's conduct. So in Williams and Second, the plaintiff argued the insurer's investigation had grossly exceeded its legitimate interests in conducting an investigation, and that this actually increased his depression and anxiety. The investigation was pretty extensive. There were about 17 investigators involved from 4 different companies. They produced 200 pages of reports. But the court found that while there were problematic aspects of the investigation, it did not rise to the level of seriousness like to warrant a special cost award. It did consider this issue of what constitutes a proper investigation to be a novel issue, though, so it went into some detail. It stated that there was nothing wrong with surveillance in concept, as long as it was conducted in a manner that was proportionate to the nature of the claim. Said it was basically a legitimate and necessary tool of the defense. And that in this case, it actually was proportionate to the nature of the claim, which was for over $2 million. It did use some cautionary language as well, however, explicitly saying that the purpose of the investigation had to be fact-finding. It couldn't be to intimidate or embarrass a plaintiff. And it acknowledged that there was potential for surveillance, if not undertaken properly, to be intrusive, upsetting, and intimidating. So it did kind of leave open the possibility that surveillance, if done in an intrusive enough manner, could potentially warrant a special cost award. Then there was a very similar case not long after of Kowalski and Chappell, also in BC. Same sort of idea. In this case, the plaintiff argued that his mental health issues were exacerbated because the surveillance, amongst other things, captured footage of his son, his child, changing at a beach, and inadvertently captured some footage of him naked. Again, though, the court found that the surveillance, while problematic, did not warrant a special costs award. Most notably, though, it commented on the insurer, sort of reprimanded the insurer, because the insurer knew the plaintiff had psychological issues and it did not bring those to the attention of the investigator. So this was problematic. And again, it left open the possibility that, serious enough conduct could perhaps result in a special costs award. Okay, I'm gonna go over to Kathleen now to talk about how to get your, oh, sorry, what? Yeah, go ahead, Kathleen. Talk about how to get your surveillance into evidence.
Thanks, Sonia. So we're going to talk a bit about admissibility now, both in the court setting and at the License Appeal Tribunal. Generally, evidence is admissible in proceedings so long as it's relevant and its probative value outweighs any potential prejudice that could be caused by its admission. And prejudice does not mean that it is unfavorable to one party's case. It means something that may distort the trial process. In a specific example, the Rumney decision that Sonia spoke about earlier, the surveillance evidence specifically from the claimant's wedding day was excluded on the basis that it would be prejudicial to her to go in. It outweighed the probative value. The court held that this woman on her best day was not necessarily a reflection of how she was on a day-to-day basis post-loss. The Ironarella versus Corbett decision I'll talk about in a bit, but it's one of the seminal decisions on surveillance in Ontario. There's a serious gatekeeping function by the judge in personal injury actions to admit evidence that is accurate and fair. And so before evidence is ever put before a jury, the judge needs to review it for same, make sure that it has not been altered in any way. For example, sped up to make it look like a plaintiff is moving at a quicker pace than they otherwise would, or edited so that specific actions such as grimacing or holding one's back, things like that, have been taken out of the footage that's going to be presented to a jury. With respect to admissibility in court, we go back to the rules of civil procedure, and specifically Rule 30, which deals with documentary disclosure. It matters to us whether you want to present surveillance evidence for substantive purposes or to impeach credibility. If you want to have it admitted for substantive purposes to show evidence of the person's activities and their abilities and what they're capable of doing, a defendant needs to waive privilege over the surveillance and disclose the reports, the video footage, and all of the evidence at least 90 days prior to trial to be able to admit it into evidence. Conversely, if strategically you want to have this evidence admitted solely for the purposes of impeaching credibility, you only need to list it in Schedule B of your affidavit of documents and provide particulars upon request. You don't actually have to disclose the entire surveillance. And just to be clear, when we're talking about the impeaching of credibility, this would be if a plaintiff specifically asserted that they could not do X, Y, or Z activity, for example, could not lift their arm overhead, or could not carry a bag of groceries, or could not walk for more than 5 minutes. And then if you have surveillance after someone has testified under oath that they can't do X, Y, and Z, you could be putting that to them to impeach credibility. There is an ongoing rule for documentary disclosure. So just a quick reminder that if you get updated surveillance after you have your affidavit of documents completed, you're required to update the affidavit of documents. And finally, you need to provide particulars with respect to surveillance upon request at discoveries. And that specifically includes the date, time, location of the surveillance, as well as the nature and duration of the activities depicted and the identity of the investigators. So we're going to talk a bit about the Iannarella versus Corbett decision. This was a rear end collision where the plaintiffs actually took a pretty aggressive approach. They did not do a discovery of the defendant, and they did not even request an affidavit of documents from the defendant. And on the eve of trial, they brought a motion for an affidavit of documents, or at least particulars of the surveillance, and the trial judge denied that motion request. Therefore, the insurer defendant was able to put a CD of about 27 minutes of edited surveillance footage to the jury and to cross-examine the plaintiff on it, despite the fact that it had never been listed in an affidavit of documents and no particulars have been provided prior to trial. On appeal, the court held that the trial judge had erred in admitting the surveillance evidence. They noted that even if that evidence had been found to be admissible for impeachment purposes, the trial judge would have been required to hold a voir dire on the fairness, representativeness, and admissibility of the surveillance, and to view the material before it was put before the jury. And the judge did not do that. The court specifically noted that if surveillance is to be used for impeachment purposes, each individual clip must be analyzed to see whether it actually goes to the plaintiff's credibility, as in each clip needs to relate to something that the claimant articulated that he or she could not do. The court held that the trial judge in this case had failed to do that. They also noted that the defense needs to lay an adequate factual foundation that the surveillance evidence can be used to impeach, satisfying the rule in Brown versus Dunn. Ultimately, at the end of the day, the court ordered that the damages verdict be set aside and ordered a new trial specifically with respect to damages in this case. The next major case we're going to talk about is Nemchin and Green. In this case, everyone agreed that the plaintiff suffered from PTSD, but there was an argument over whether the PTSD was as serious as she said it was, and an argument over whether the PTSD was a result of an earlier assault. The defense sought to introduce video evidence that established that the plaintiff's activities were not as limited as she said, and some of the videos were disclosed inadvertently late, approximately 2 weeks before the trial started, though other pieces of surveillance evidence and video were disclosed well in advance. Based on the late disclosure, the trial judge ordered that none of the surveillance evidence could go in, and the plaintiff was awarded $700,000 in damages. The defendant appealed, arguing that the judge erred in failing to admit the surveillance as well as Facebook evidence. And the Court of Appeal agreed with the defense. It held that the judge erred in excluding this evidence. It stated that late disclosure is usually not a good reason for excluding relevant evidence, where it is similar evidence to that was disclosed on time, so that the plaintiff and her counsel were not unfairly caught by surprise. At the end of the day, though, the court basically found that even if the surveillance had gone in, it would not have affected the jury's verdict on damages, and the court did not order a new trial in this case. Switching over to the License Appeal Tribunal, this is governed by the disclosure rules in the common rules. Specifically, Rule 9.2 provides that a document needs to go in at least 10 days before the hearing, needs to be served at least 10 days before the hearing or at any other time as ordered by the tribunal. In our experience, it's the second portion that you need to pay attention to when the tribunal issues an order for productions and a deadline for productions. That is the one to follow. You're on precarious ground if you're waiting till that 10-day deadline, hoping that something will get in if there's a prior order for production. In the case of FC and Aviva, the respondent filed its surveillance after the deadline set out in the case conference report and order. It was served approximately 1 month prior to the hearing. And at the end of the day, the adjudicator actually allowed the evidence, holding that there was no sufficient evidence of prejudice to the applicant for it to go in. In the case of 2535 versus Aviva, the insurer served its surveillance late. Specifically, it served it with its submissions. In that case, the applicant was successful on a motion to have the surveillance excluded and was awarded costs. This case went up to a reconsideration. and the cost order was set aside, but the tribunal did not reverse its decision to exclude the surveillance evidence. It found that this was a fair remedy for the respondent's breach of the rules. In Krekukias versus TTC, the exclusion of the surveillance, this time it did not go in, was actually based on 3 reasons. The respondent had missed some ordered deadlines. The adjudicator actually held that the prejudice of the applicant outweighed the probative value of the surveillance. And I think particularly importantly, they made a finding that the surveillance was not relevant to the issues in dispute. So one would think that even if the surveillance would have gone in, it would not have formed part of the adjudicator's decision on the issues. We just want to take you through a few best practices now about what insurers should do in first-party claims, court proceedings, and in all other contexts. Specifically, insurers should have a written and clear policy that sets out certain guidelines for when surveillance is and should be conducted. The Ontario Privacy Commissioner also recommends that the insurer have a written service agreement with their investigation company or companies, which provides clear guidelines to those companies. And just a final note of when you're trying to get your surveillance in, what you're going to need to prove either at the LAT or at court. It's got to be relevant. The probative value must outweigh the potential prejudice, and it must be properly disclosed. In court, the evidence will be scrutinized further by a judge before it ever gets to a jury to ensure that it is fair and accurate, and you need to comply with your obligations to list it in Schedule A or B of your affidavit of documents, depending on how you're going to use it, as well as to provide particulars upon request. The License Appeal Tribunal is much more relaxed about letting this evidence in, but it needs to be related to the issues in dispute, and you need to comply with all orders from the tribunal about deadlines for documentary disclosure. Thank you very much for attending, everyone. If you have any questions, please let us know. You can put them into the chat. And while I'm waiting for that, I'm just going to let everyone know about our next webinar. This is a MIG update for 2022. It's taking place on July 28th and being presented on by my partner, Julianne Brimfield. We know that the MIG presentation last year was very helpful and very well attended. So if you want to know the current trends at the License Appeal Tribunal, please mark the date in your calendar and Julianne will be happy to let you know all about it.
And before anyone asks questions, just in case anyone has to go right away, if you want a copy of our slides, you can just shoot us an email and we're happy to share those with you.
Yeah, absolutely. So it looks like we don't have any questions coming in and we are a bit over the promised time. So we're going to let everybody go, but we really appreciate you attending today. Thank you for listening to our presentation and thank you for your patience at the beginning while we sorted out the issues we had. Have a great day, everyone.